The question often comes up for families like yours who have inherited a property because a loved one has passed away. And now you're trying to decide, can we sell the home while we're in the process of going through probate? That's what today's video is about. The short answer is yes, yes you can. But sometimes I find when I meet with families that they've done things kind of out of order or they've skipped a step. And so that's what today's video is about. I want to make sure that I give you some bullet points so that you do things correctly and don't cause yourself even more stress and make that process a little bit more smoother. Okay, so that's what we're going to talk about today. Of course, as usual, I have my little notepad here so I don't miss anything. So first things first, when you go ahead and start the probate process, most likely you can try to do it on your own, but most people have an attorney. So the attorney is going to file with the courts to have a personal representative assigned to manage things, okay? So let's say there's 3 siblings involved. They're probably going to pick the one that was already noted in the will. For my videos, especially this one, I am going to be talking about an informal probate. An informal probate is where a will was found. We're going to go ahead and abide by everything on the will and not make this all complicated. So a formal probate would be if there wasn't a will and family is not getting along. We're not going to talk about that. We'll talk about that in a future episode. But for today's episode, we are talking about an informal probate. Easy peasy. There was a will. We know who the executor is, and that's who they're going to assign as the personal representative. You kind of want to start that process earlier if possible, only because it also allows you to pay bills out of the estate. You can't do a whole lot without that being assigned personal representative, and then the courts will also issue you what's called a letter of an appointment or a letter of testamentary. I'm going to say letter of appointment because that's easier to say. So anyway, you're going to get this letter and it'll say letter of appointment, and this party also agrees to be personal representative. So you will get that form now provides you the documentation that you need to be able to sign legal documents on behalf of the estate. So you'll sign everything like John Smith as personal representative. Hopefully that makes sense. Okay, so the court is going to appoint the personal representative. The personal representative is going to receive that letter of administration or appointment or testamentary. You pick whichever vocabulary you want to use. This document then authorizes you to act on behalf of the state. I just said that, didn't I? I'm just going back over my bullet points, okay, so don't miss anything. Then you are legally allowed to sign a listing agreement with a real estate professional. That's what I do for a living. I help families just like you help sell the inherited property that's in the estate. If you happen to meet a real estate agent, or let's say you kind of put the cart in front of the horse a little bit, and you're like, let's go ahead and get the house on the market. You meet with a real estate agent, you go ahead and sign all the documents, and you don't have this document that you need from the courts, you don't have a legal authority to sign it. And if the real estate professional you're meeting with has not asked for that, that is a huge red flag. Because, God, is it echoey in here? I moved a rug to mop, so it's a little echoey. Sorry about that. But anyway, you are going to need that documentation. So again, it's kind of a red flag if a real estate agent that you chose to hire is not up to speed on what documentation is going to be needed. Okay. Secondly, before you go list the property, you need to make sure that you're getting a good valuation on the property at the time the person is deceased. I know, you're like, Lynette, seriously, you want me to hire an appraisal? I've got all these other things I got to deal with. The answer is yes. You are going to want to have the property appraised so that you have a good value for the property at the time the person passes away. Your attorney may want that. Your accountant may want that. That helps provide to them how much the house was worth at the time that they actually passed away. I know. Not just one more thing you don't want to have to deal with, but sorry, you're going to have to deal with that. Okay, one of the mistakes that people tend to make is We're trying to sell mom's rental property. So that's part of one of the properties in the estate. And there's tenants in there. Can you sell that property? Yes. However, those tenants may have a legal occupancy to be there. They may still have a legal lease to be there. So you want to make sure you try to find that lease documentation. Hopefully you can find it. And then find out when is their lease up. You probably want to give the tenants notice at that time, like, hey, we are going to be selling the house as part of the estate. Maybe give them option to purchase it if they want to. However, when it comes to trying to show that property, sometimes you'll get people that are like, well, I'm just going to sell it to an investor because there's already tenants in there. Yeah, that's great. But is that what everybody else in the family wants? Because if you have a tenant that's been in that home for a minute, there's probably going to be some repairs that are going to be done to that house, which they're going to want if they're going to buy the house from you, but also if you go to try to sell it on the resale market as well. I had a client who was doing just that with her mother's property. The tenants had been in the house for over 10 years. One of them was wheelchair bound, and the flooring wasn't conducive for a wheelchair. So they were using their wheelchair over the carpet, which just ended up leaving ruts up and down the hallway, and the path that people normally walk. It'd be no different than having a path where you walk at every day, but in this case it had broke down the padding and the carpet. It was pretty bad shape. Those tenants were not in a position to buy the house, so we had to get some work done on it. She did have authority to go ahead and sell the house, so we went ahead and signed the listing agreement, but saying we were not going to put it in a marketable position until these things were done. She had some siding issues. That's one thing that we can discuss if you reach out to me about listing your loved one's home in my area. But also, if you don't live here in the Phoenix metro area or in Arizona as a whole, I can certainly hook you up with an agent that works in your particular market. But one of the things they might recommend is let me get in the home, figure out what needs to be done, what's going to make it sell for the most money if that's the route you want to go. Okay, so don't hesitate to reach out. I'd be happy to make those connections for you. But you cannot ignore those occupancy issues, okay? Not only that, if you do decide to sell the house and there's a tenant still in it, you have to, at least here in Arizona, you have to give them 48-hour notice. You can't just willy-nilly let somebody in the house look at the house. You have to give them 48-hour notice, just as if you're now the landlord. So it makes it really, really difficult. If it was me, I would advise the tenants you need to sell the house, see if they want to buy it. If they don't, I would go ahead and give them notice that you're not going to renew their lease. And that could be a couple months, it could be 12 months. I don't know how long ago they signed the lease, but do know that that's something that you're going to have to deal with. If you need some guidance on that, just feel free to reach out. And if you have any questions about this process, go ahead and comment below. I'd be happy to help answer any questions that I can. Of course, I'm not an attorney and I'm not a CPA, so don't ask those kinds of questions. But if you need one, let me know. I'll hook you up. Okay. Number 4, you're gonna want to try to understand the courts and the timelines. This timeline can actually take a bit of time. So don't just think that willy-nilly, I'm going to go ahead and list the house and we're going to be done with this whole process in a couple months. Just go ahead and get into your head now. This could take anywhere from 4 months to a year, depending on how cooperative the family is, that sort of thing. And don't rush any decisions. It is amazing to me how many people I meet in this situation where they have a few siblings involved. One sibling's like, let's call an investor, let's just get rid of it. I just really don't want to deal with it. And then of course there's the analytical one like me that's like, I'm not giving up an extra $100,000 because you don't want to deal with this. So don't rush decisions. Make sure your family members are all on the same page, okay? Because again, this is going to be really stressful on one member of the household and maybe not so much on the other. So if you need help being that mediator between you and your siblings, that's what we do as well. Not that it's in our job qualifications, but we seem to do that all the time. Now, there are going to be a couple exceptions that you don't need to wait and go through the probate process to sell the property. So in September of 2025, here in Arizona, they passed a rule that if the value of the real property is under $300,000, then the successors may not need to go through the probate process. Again, it just depends on their overall portfolio. So if they have their single family home or their condo, let's say, and it's only worth $250,000, then you may not need to go through the probate process. But again, ask your professionals, like not your real estate professional, but like your attorney, that sort of thing. Because maybe there's an extra property in there that you're not aware of out of state. And then whoop, there we go. Now the whole portfolio is now over a certain dollar amount. But again, make sure you ask your attorney about that one, okay? I actually did help a lady back in October of 2024, I want to say. She was handling the estate for a dear friend. The friend did not have any family. They didn't have a will, but they did evidently have some explicit instructions in there to call her as an emergency contact. And lo and behold, she became the personal representative and had to handle the whole estate. Well, because it was a condo, it wasn't worth more than $300,000. They actually ended up giving her what's called a deeded distribution. So they just deeded the property right over to her through the courts. So sometimes you get kind of lucky there. And who knows, while you're going through the property and going through their possessions, maybe you run across trust. Hallelujah. That would be amazing, as long as the house is it's titled in the trust. So again, those are documents that you want to look for when you're going through the items. And if you don't know exactly what to keep and what not to keep, I did do a video that you can find that talks about what kind of paperwork you want to keep a hold of when you're going through your loved one's belongings. So make sure you tune into that. And I haven't decided what I'm going to talk about next week yet, but you probably should go ahead and subscribe, because I bet it's going to be a good episode. I think I'm going to be talking about what you're supposed to be doing as the executor of the estate. That's probably a topic I need to cover next. So thanks for tuning in. I appreciate you. And if you need any help at all, don't hesitate to reach out. All right, we'll see you on the next one.